Thank you, Mr. Vice President. Chair, Excellencies, honorable participants. It's a pleasure to be here again for my second interactive dialogue with you to address issues related to my mandate as Special Rapporteur on the independence of judges and lawyers. I will begin by discussing my 2 official country visits, then I will present the findings from my thematic report. During the afternoon session, I will discuss concerns arising in the context of communications. Turning to my country visits, I visited Montenegro from 19 to 26 September last year. I reiterate my gratitude to the authorities of Montenegro for the invitation and for their support in the preparation of the visit. I was happy to meet with judges and prosecutors from lower courts and prosecution services in Podgorica, Bielopolje, and Kalashin. Montenegro has made considerable progress in reforming its institutional and legislative framework, particularly since the beginning of the accession process to the European Union. The constitutional amendments of 2013 and new legislation regulating the judicial and prosecutorial career have contributed to the depoliticization of the judiciary and the prosecution service. There have also been significant advances in the fight against corruption and organized crime. However, the justice system of Montenegro continues to face legislative gaps, institutional shortcomings, and practical problems that undermine the independence and impartiality of the judiciary and the prosecution service and limit or prevent access to justice. Legislation does not currently address important aspects of the career of judges and prosecutors. The current composition and functioning of the judicial and prosecutorial councils is not sufficient to protect them from external interference. More needs to be done to ensure that lawyers are free to carry out their professional activities without any undue interference or pressure. I encourage Montenegro to continue its reform of the justice system in line with existing norms and standards relating to the independence of the judiciary, the autonomy of the prosecution service, and the rule of law. At the same time, more should be done to improve the salaries and working conditions of judges and prosecutors. I urge all political forces to work in a fair and collaborative manner to find a durable solution to the deep institutional crises that have led to limited operation and functioning of the Constitutional Court, the Judicial Council, and the State Prosecution Service. I also urge politicians and state officials to refrain from damaging statements concerning the judiciary and the prosecution service that could amount to interference. Finally, I call on the authorities of Montenegro, together with the Bar Association, to ensure that legal aid providers are subject to applicable professional codes of conduct and establish appropriate oversight mechanisms for legal aid providers. More steps should also be taken to ensure the accessibility of court facilities and procedures, and to ensure adequate specialization in sensitive and complex cases, such as those involving family or intimate partner violence. Turning to Mongolia. I visited Mongolia from 6 to 15 November 2023. I wish to reiterate my gratitude to the Mongolian authorities for the invitation and for their support in the preparation of the visit. I was pleased to visit judicial premises in the Chinglete and Subakhtar districts of Ulaanbaatar, in Selenge province, in Mandalsum, and in the cities of Darkhan-Ul and Baganur. I recognize the efforts of Mongolia and its many achievements in reforming its judiciary since the country's transition to democracy and the adoption of its constitution in 1992. Constitutional amendments in 2019 and the enactment of the new law and courts in 2021 brought several key changes to strengthen the independence of the judiciary. For example, the 10 members of the Judicial General Council are no longer appointed by the President, and an independent judicial disciplinary committee has been established. During my visit, I also noted and welcome efforts in progress to review the criminal codes and a new bill on the establishment of courts that was under consideration, including provisions to address the importance of timely and unhindered access to counsel as a guarantee of the right to fair trial, as well as to ensure that no detention is arbitrary by seeking to ensure 24-hour access to a judge. Chronic underfunding was the most frequently reported problem during my visit, and I note that there has been no nationwide capital investment in court or judicial infrastructure for a decade. I call on Mongolia to earmark a percentage of its budget for the judiciary. I was concerned to hear from many counterparts about the lack of public trust in the judiciary. Increased knowledge and understanding are vital to increasing trust in judicial processes. Therefore, greater transparency may increase faith in the justice system. I welcome the steps Mongolia has already taken to address this. In particular, the fact that many judges are taking proactive steps, such as providing a simple summary of court decisions, or even going into communities, sometimes using their own resources. I note that deficiencies in infrastructure contribute to a lack of trust by preventing the public or civil society from observing or participating in proceedings due to a lack of appropriate space in courtrooms. Furthermore, adaptations are required to permit persons with disabilities to participate fully. The prosecution service must also take steps to come into line with international human rights standards. Mongolia should consider the creation of an independent body similar to the Judicial General Council for the prosecution service, empowered to oversee appointment, discipline, and dismissal. Finally, I call on Mongolian authorities to ensure the ability of defense advocates to play their crucial role by ensuring they have prompt, unhindered, and effective access to case files and their clients. Vice President, Chair, Excellencies, and honorable participants, I will now turn to my thematic report. In my thematic report for this session, I addressed the vital role played by independent judicial systems and personnel, judges, prosecutors, lawyers, and community justice workers in safeguarding democracy. Democratic participation in political life is an essential human right enshrined in the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. Political participation is also a tool for protecting and advancing other fundamental human rights. 2024 has been called the biggest election year in history, a landmark for democracy in which nearly half the world's population will vote. But meaningful democracy requires more than elections alone. And research shows that indicators of meaningful democracy, including adherence to the rule of law and the existence of checks on governmental power, are in decline across the globe. Increasingly, governments who come to power through legitimate elections later wield their power to undermine democratic systems and rights. In many states, such attacks on democracy have justice actors and justice systems as their target. On the other hand, the existence of strong, independent judicial systems can be a valuable bulwark against autocratizing and anti-democratic forces. I explore this nexus between independent justice systems, the rule of law, and meaningful participatory government in the report I present to you today. To prepare the report, I publicly issued a call for inputs from state civil society organizations and academia. I was able to draw on more than 89 such submissions, along with information gathered in 5 online consultations with interlocutors from 43 countries. I'm extremely grateful for all the contributions I received and for the important contributions by civil society, which played a valuable role in refining my analysis. Today, I wish to highlight 2 findings from my report: the many reasons why independent justice systems are important to maintaining meaningful democracy, and the extensive challenges to those systems that we are facing when they attempt to play that role. But first, why do justice systems matter to democracy? Most importantly, because justice systems uphold the rule of law, which require governments to act in accordance with the power vested in them by the people. Independent justice systems ensure that all people are equal before the law, including governments and political leaders. In doing so, they help to guarantee that state action is legal, constitutional, and compliant with international human rights law. And they check undemocratic usurpations of power. Justice systems also play a critical role in ensuring free and fair elections, adjudicating disputes on the fairness and lawfulness of electoral proceedings. Second, in what way are independent justice systems being challenged in their attempts to uphold democracy? In my report, I identify 4 categories of threat to these systems: capture, curbing, instrumentalization, and attacks. Capture of courts and bar associations involves reforms that decrease independence and increase political control, with the impact that these systems can no longer act as an effective check on governmental power. Curbing takes place through legal changes that systematically reduce the power of these institutions to act, especially in relation to possible abuses of power by the political branches. Instrumentalization entails abusing justice systems to influence or control individual justice personnel through politically motivated prosecutions and disciplinary proceedings, or by manipulating conditions of service. Finally, individual justice operators may be subject to attacks and interference, such as public disparagement by government officials, harassment and threats, and even arbitrary detention, torture, enforced disappearance, physical violation, and assassination. Such targeting of individual judges, prosecutors, lawyers, and community justice workers may serve as punishment, retribution, or warning for their work to challenge the legality of government action, represent political opponents, or uphold fundamental human rights. In every case, the result is the creation of an unacceptably hostile environment, chilling and deterring other justice workers from acting to defend democracy and undermining the rule of law. Vice President, chairs, excellencies, and honorable participants, I will reserve time to address some of the key issues arising in the context of communication after our lunch break, and I look forward to this discussion. Thank you.